So Grahame and I are going to talk to you about the new duty to prevent, allow me to pause and emphasise that, prevent sexual harassment. So the background to all of this is we will all remember the groundswell arising from the Me Too movement and the perception that something needed to be done in order to address sexual harassment in the workplace. It's probably fair to say that when looking at these provisions, they have something of the flavour of, we need to do something, this is something, and so let's do it. Because precisely how these provisions are going to strike a blow in terms of preventing sexual harassment in the workplace is something that, I'll be honest, I struggle with, and Grahame has the joy of telling you what these provisions in fact mean, and in that regard I wish him luck. But essentially what the purpose of the provisions is that they introduce a new duty to take reasonable steps to prevent the sexual harassment of employees, which we'll refer to as the new duty for the remainder of this talk. There is then a power/obligation on the part of employment tribunals to increase compensation in circumstances where the new duty has not been complied with. But no freestanding causes of action whatsoever are created. And so how this is going to interact is a little difficult to predict. But new duty can also be enforced by the Equality and Human Rights Commission, subject to its enforcement powers. And two important things to recognise about these provisions is they involve a degree of compromise, in the sense that the government did want to take more significant action than eventually we see in the statute book. Two amendments which were made in the House of Lords, which in the end the government adopted, were firstly the decision or the proposal to reinstate the provisions about third-party harassment, which, as you recall, were in the Equality Act, were never brought into force, repealed in 2013. Well, they had the opportunity of returning, and now they're not. Also, the House of Lords amendment removed the requirement that the employer take all reasonable steps in order to avoid sexual harassment, and the position is now whether reasonable steps have been taken. So, new duty. Set out at section 40A, you must take reasonable steps to prevent sexual harassment of employees in the course of their employment, and sexual harassment means sexual harassment as defined in section 26(2) of the Act, with which we're all familiar. So, points to note, take reasonable steps, not all reasonable steps. How important a distinction is that? We'll have to see. Note also, it is a general duty which applies to employees in the course of employment. No specific perpetrator is identified. Even though the restoration of the third-party liability provisions was not carried through, the parliamentary sponsors of the bill are clear in their assessment that this duty does engage or capture acts of third parties. So, point to bear in mind that whilst you don't have a cause of action for the actions of third parties, or a cause of action can be brought against employers for the actions of third parties, the actions of third parties can potentially be relevant to this new duty. Now, does it remind you of anything? Well, immediately, many of you may think, well, that sounds a bit like the statutory defence under section 109(4) of the Equality Act, which is set out there. Points to note that instead of all reasonable steps, which appears in 109(4), as I've said several times, the duty under the new section 40A is just reasonable steps. Also, this is a targeted duty under section 109(4), because the steps are targeted at protecting A from harassment by B, rather than sexual harassment at large, which suggests a relatively wide scope, as Grahame will discuss, to the new duty. And this defence has to be pleaded, or at least pursued, which isn't the case with the new duty. We then have the compensation provisions. So there's a number of triggers in this section in order for the new or the compensation uplift for breach of the new duty to apply. So firstly, a tribunal has to have found that there's a contravention of section 40. So there has to be a successful harassment claim. Next step, the tribunal must have ordered the respondent to pay compensation in accordance with section 124. So harassment leading to compensation. If those two gateway conditions are met, the tribunal must consider whether and to what extent the respondent has contravened section 40A1, so the new duty. If the tribunal is satisfied that there has been a contravention of section 40A1, it may order the respondent to pay an amount to the complainant, and the amount of that uplift must A, reflect the extent to which, in the tribunal's opinion, the employer has contravened section 40A, with no more than 25% being awarded. So that's what the statutory provisions say. I'm going to hand over to Grahame, who's now going to attempt to tell you what they mean. Then we'll circle back and I'll adopt matters from the perspective of a claimant and things that claimant representatives might be wanting to advance in this regard. Then Grahame will finish with adopting the position on the part of the respondent. Over to you, Grahame.
All right, thank you. Of course, we're looking at a new duty here, the exact shape of which remains unclear, at least for the moment. Now, on any view, it might be said that given that Parliament has decided that something must be done or something must be changed, we can conclude that something in the law must indeed have changed and that we are moving into territory in which the claims and defences that can be successfully brought and pursued may be changing. We're going to be grappling for some time with the precise parameters of what indeed has changed or perhaps has not changed. Some features just on this slide that Nick ended on, I just want to focus on before I move into an example of how, in fact, the position may have changed. If you look in relation to the compensation provision we have here, you succeed in a harassment claim, any form of harassment. Doesn't have to be sexual harassment. The power to grant an uplift comes into play where sexual harassment was involved to any extent. And what we have at the moment is no idea particularly just how involved the sexual harassment must be. You've got two instances of harassment. The harassment that causes you to succeed in the claim, but then, if I can put it like this, the background sexual harassment, which is going to become the battleground when we start talking about uplifts. But just what is the connection between those two? It doesn't seem that there has to be any beyond the case in some way must involve sexual harassment. We're going to need some guidance as to just how far in the background that the sexual harassment has to be. Let me move on then to an example that we've worked up. Imagine someone works in a pub and she's sexually harassed by a customer of the pub. So, as Nick said, we haven't brought back in the third-party provisions. So, in principle, that's not actionable. Even if she brought a claim in time, it wouldn't succeed. Or she could have been harassed, but the claim is out of time. But it's sexual harassment. She then raises a grievance about it, and she is harassed, not sexually, in the course of bringing that grievance by a manager who, for example, says, "Oh, you always complaining, insert protected characteristic here." Is that first instance of sexual harassment something that is relevant today as the law stands? Probably not, although possibly injury to feelings or something. But as a matter of the ordinary paradigm, no. But as we move into this new world, following this new duty, well, theoretically, or perhaps more than theoretically, it could be. The first question, of course, is this first instance of sexual harassment, the background harassment, of a kind that's in section 26(2), and it is, because it seems to be sexual harassment. There is no requirement with the new duty that it be sexual harassment, which if you brought a claim about it, you would succeed in. The customer example, obviously you wouldn't. If it was out of time, you of course wouldn't. And this, of course, is a very promising or attractive way round time limits, because if, say, the example was a colleague rather than a customer, you'd failed to bring your sexual harassment claim in time, well, you wouldn't be able to bring a claim about it per se, but all of a sudden it becomes very relevant in the assessment of any compensation you're going to get to nevertheless complain with a small c about the sexual harassment you received but that was out of time. So in principle, this example seems to work on the basis of the new duty. And of course now already claimants will be thinking, I'm bringing a harassment claim. Can I think of anything in the background that I could add as an instance of background sexual harassment? They're going to be brainstorming those. And then in the course of that brainstorm, they're going to have to think, all right, but just how involved does my primary claim have to have as a connection with this background sexual harassment? And that's what we're not very certain about. This seems to be an example where the involvement, the nexus between the background sexual harassment and then the foreground primary harassment is relatively clear. But what about this example? What if claimant's going through a grievance, manager says, typical whatever, always complaining rather than working. And the claimant says, well, I was particularly upset by that comment because 15 years ago, when I worked at a different pub, I was sexually harassed and I didn't complain about it. And therefore, I feel as if I'm not somebody who always complains, but this has brought it all back to me. Well, is that a claim, and she succeeds in the primary harassment, is that a claim which to any extent involves sexual harassment? Yeah, it probably is. How far can you take that? We don't know, but on the face of it, it seems to be you could take it pretty far. And we're going to need EAT guidance, I think, about exactly just how involved the two types of harassment have to be. Now, turning to the duty itself, we're expecting EHRC guidance about this. One point I should make is, if, as is widely expected, the government changes in a few weeks, the party which everyone thinks is going to win the election has already said that they plan to create a single enforcement body for employment law, which will take some functions from bodies like the EHRC, bodies like HMRC to the extent that it deals with national minimum wage and so on. Will those changes have the effect, A, of slowing this down? Quite possibly. Will it also have the effect of depriving the EHRC of its enforcement functions in relation to this sort of duty, and bringing them into a single enforcement body? We don't know, but that could be a change, a further change that's on the cards. Nick flagged it a couple of times, and without this sounding like a facetious question, you don't have to take all reasonable steps, but how many reasonable steps do you have to take? Is one reasonable step enough? Well, no, it's in the plural, so 2 reasonable steps, presumably, on the face of it would be enough. Or is it most reasonable steps? Or is it such steps as it's reasonable to have to take in the circumstances or something of that sort? We just don't know. What is also clear is that the duty is to prevent sexual harassment at large. It's not necessarily a duty to prevent the sort of harassment that, if it's sexual harassment, that constitutes the primary harassment I was talking about. It doesn't seem to be a duty focused on taking steps to prevent the sexual harassment that's in the background that gets you the uplift. It seems to be a duty to prevent any form of sexual harassment at all. So what about if, in our example, the claimant said, you're in breach of your duty because you didn't take reasonable steps to prevent customers from harassing me, Well, we took all reasonable steps to stop your colleagues harassing you, wouldn't seem to cut the mustard. What if, in that example, the employer were able to say, well, we took all reasonable steps to stop customers harassing you, we took all reasonable steps to stop anybody in your pub harassing you, but actually in the pub 2 streets down the road, yeah, we didn't take reasonable steps in that pub. Well, have they breached the duty? Yeah, because it doesn't seem to be a duty focused on the individuals in question in the claim. It's a global duty. So again, you can see the grist to the mill for claimants who want to find things in the background, even if they are themselves unaffected by this duty. Theoretically, they can produce evidence if they want to, or put into dispute these sorts of matters. So now you may say, and this may well turn out to be right, that that's a rather absurd example, and employment tribunals may take the view that it can't have been intended to require, as soon as you win on a harassment claim and in some distant background there is some sexual harassment, we are going to conduct a public inquiry into compliance across a whole employer in relation to sexual harassment. But theoretically it's possible. And you can see how, in the dynamics that we get into when we're talking about the risks involved in claims, settling claims, these are the sorts of things that employers are going to be worried about losing on, but frankly worried about even having to give all the evidence on and disclosure on and so on. Compensation oddities, again, coming back to Nick's point that this seems not perhaps to have been fully thought through, at least at the legislative stage. We have a compensation uplift of 25%, something we're quite familiar with as employment lawyers. And it, again, seems to require there to be no nexus between the relevant harassment and the breach of the duty more broadly. But one would imagine that when setting is it going to be a 1% uplift, is it going to be a 25% uplift, presumably the extent to which the claimant in question was affected by the breach of the duty may well be something that's relevant. But you will note that although you'll have seen in the previous slide, there is a discretion as to whether or not to grant an uplift at all, there's no discretion about the extent of the uplift, save that it must reflect the gravity of the breach of the duty. And again, just because you, the claimant, are not particularly affected by the breach does not mean there's not a serious breach that has to be reflected in the uplift. So you could find yourself with a windfall, having not been particularly affected by a breach, but able to point to some serious breach elsewhere that gets you access to something like a 25% uplift. A further oddity, there does not necessarily seem to be a nexus between the damages for sexual harassment or the primary form of harassment that one receives, and then what the uplift in fact binds on. And theoretically, looking literally at the Act, if you were, for example, to win serious loss of compensation, loss of earnings for a discriminatory dismissal, for example, and a very small amount of compensation for harassment, the 25% uplift, if that's what you get, applies to the lot, not just the harassment. So again, a very large, potentially a very significant development in the way the law operates. This is you, isn't it?
It is. So, from the perspective of claimant representatives, the point I would make is this. Parliament appears to have handed you one hell of a stick, and I would suggest that you seek to use it. Because what one has is a situation where, in principle, historic allegations of sexual harassment, which may have absolutely nothing whatsoever to do with the subject matter of the claim, are then potentially relevant. So what is important, I think, is to put this issue front and centre in early correspondence. Now, I've already said that there's no duty to plead, there's no requirement to plead a breach of the new duty in the same way as you would the statutory defence if you were for a respondent. If I were a claimant, I would be pleading breaches of the new duty, because the reason to do that is obviously to make plain that this is something that is going to be investigated and to trigger disclosure obligations. And pre-issue, it seems to me that a claimant's representative ought to be exploring, firstly taking instructions from their client as to the extent to which there may be breaches of the new duty, and then seeking information in that regard from the respondents. And very often you'd be met with, well, it's a fishing expedition. Well, now you say, well, no, because there's a new duty and we need to understand. So we may, as I say at the final entry, we may be returning to the halcyon days of discrimination questionnaires, where you're asking questions, and for the first time it actually matters what they've done about sexual harassment in the last 10 years, how many complaints they've had, how many have been upheld, those sorts of things. Because this is very much material that you would want to put in front of the tribunal, that you would want to cross-examine on, because potentially it opens up significant compensatory advantages for your client. And it's an obvious pressure point in terms of settlement. So having said that, Grahame will tell you why I'm wrong.
Well, not quite, because
God bless you.
because inevitably the respondent lawyer position at the moment is something of a watching brief to see how the law develops. But it's not particularly satisfactory for clients who want to get ahead of this, and they ought to be trying to get ahead of this. Of course, you're going to have to be responsive in claims and proactive. I think there's very often, you may find in a pleading, at the end of a long pleading, oh, and by the way, new duty in relation to sexual harassment, and we put that in the too difficult to deal with at the moment drawer. Understand that temptation. It might be one that we ought to resist and try and get ahead of. There's all sorts of stuff that no doubt will come as no surprise, and it's the sort of thing that we tell our clients and our clients tell themselves that they do all the time. But as a matter of practical reality, doing these things like training, educating staff about the culture that's required, is perhaps not always A, done, or B, recorded as it should be. Inevitably, as with all litigation, but in particular in something that I think is going to be something of a flashpoint in future, the more you can get on paper, the better. The more you can say, yes, Joe Bloggs did attend sexual harassment training on the 15th of January, and yes, he did stay for the whole day, etc., is going to be of critical importance. There are other suggestions I put on the slide, which of course you can take away with you. Keeping records, I think, is the most important thing. Keeping your eyes peeled, is that the expression?
Yes, it is. Yeah.
For this EHRC guidance, such as it is going to be important. Two additional things. I think a good strategy at this stage, if your respondent client is going to come up with a strategy for demonstrating how it complies with the duty, and it should do that, an excellent way of trying to bomb-proof it for the future would be to put that strategy to the people who might in future complain about it. So unions is a good example, but of course if you have groups within the workplace that deal with sexual harassment or deal with equality matters, and say, this is what we plan to do, we think these are the reasonable steps to take in this context. What do you think? They may say, well, we think you should also do A, B, and C. And you can say, well, we'll do A and B. We're not going to do C because we don't think that's reasonable for this reason, which is now on paper forever. That strikes me as a good approach to future-proof yourself. And then this point at the bottom, of course, very rarely do respondent clients take the statutory defence. A, you never win. B, it increases hassle and cost. C, very often you have another employee that you want to stand by. But of course, this new duty would appear to incentivize you taking it. Because if you are going to have to go over the coals anyway about the extent to which you did indeed take reasonable steps to prevent what happened or something like what happened, well, why not take the statutory offence if you're going to have to go through it all in any event? And that is a position that clients are going to want to have to think about in more detail than perhaps at the moment we encourage them to think about it. So these are some points that I think respondent clients might think about. We may well, at the next extravaganza, be here giving you an update on how we were totally wrong about all of this and the law's barely changed at all.
Something to look forward to.
So that's something to look forward to. But for now, those are our thoughts on how it works.